Public Protector Advocate Protector Mkhwebane is to release several investigation reports at her quarterly media briefing. Let's cross there right now. So,
Chief Operations Officer, Ms. Protector Mkhwebane. Next to me here is the Chief Executive Officer of the Public Protector South Africa, Mr. Protector. And of course, we have the Public Protector Advocate, Protector Mkhwebane, who now has the floor to address the House. Over to you, people.
Thank you, Program Director, and welcome again to Public Protector South Africa. Thank you for honoring this invitation. I'll be issuing reports for the first quarter of 2018-2019 financial year, and I have a duty to do that in terms of the Constitution and the Public Protector Act. Therefore, I can use any form of publishing my reports either through media briefing or uploading them on our website or then sending them through social media. My office recognizes that the news media remains the most effective way through which we can comply with these constitutional and legislative requirements. We therefore continue to rely on you to bring to the attention of the public the outcomes of the critical work which we are doing as an office. Allow me to remind you of the simple but most powerful words by Chief Justice Mkhwebane when he handed down the historic judgment in the matter of EFF and others versus the Speaker of the National Assembly, in the case where this judgment was delivered in March 2016. The ruling read, I will quote one paragraph in that judgment. The tentacles of poverty run far, wide, deep in our nation. Litigation is prohibitively very expensive and therefore not an easily exercisable constitutional option for an average South African. For this reason, the fathers and mothers of our Constitution conceived of a way to give even the poor and the marginalized a voice and teeth that would bite corruption and abuse excruciatingly, and that is the Public Protector. One of the key takeaways from this particular extract of that definitive judgment is the reference to the severity of poverty in our nation and the emphasis on how this office is the voice and the teeth with which the poor and the marginalized can pull themselves out of the doom and gloom. Uppermost in my mind when I walked into this office in October 2016 was this idea of a public protector as a refuge for the poor and the marginalized, a resource through which they could hold their leaders to account and in the process improve their quality of life so that they too can enjoy the fruits of freedom and democracy. I have since been engaged in a relentless effort to rally the Public Protector South Africa, a team of capable, experienced, and devoted men and women in pursuit of what I call Vision 2023, a detailed plan that simply seeks to take the services of this institution to the grassroots. You may wonder who or what I refer to when I say the grassroots. In simple terms, the grassroots are the poor and the marginalized, who Chief Justice Mkhwebane referred to in the landmark judgment I quoted. It is the masses who day in and day out toil in the farms to earn an honest living, but struggle to put food on the table, live under horrible conditions, and have neither job security nor security of tenure. It is those who live and raise children in inhabitable makeshift structures, which they call homes, homes that are prone to fires or flooding during inclement weather. It is those who, in their hour of need, turned away at the gates of public hospitals or clinics to go home and die because the facility is closing or there's no medication to assist them. It is those that are fortunate to hold a decent job and have a regular income, but it is not nearly enough to afford them a lawyer when they want to litigate against the mighty state. All this and more are their realities, despite the fact that every year without fail, budgets are passed for 47 national government departments, 110 provincial government departments, 257 metropolitan, district and local municipalities, as well as hundreds of other organs of state and public bodies. Alive to these realities, the team and I devised the Vision 2023, which is propelled by 8 pillars: enhancing access, using indigenous languages to communicate, expanding our footprint, leverage stakeholder relations and signing agreements in that regard where we can expand our footprint, empowering people to understand their rights, projecting an image of a safe haven for the poor, encourage the establishment of effective internal complaints resolution units, and turning communities to be their own liberators. The end of this week will mark exactly 20 months since I walked into this office to spearhead the mammoth task of taking the services of the Public Protector to the grassroots per Vision 2023. In the year 2016, 2017, and 2017, 2018, we have had a total workload of 25,288 complaints. Out of this, we finalized 21,176 complaints. I must indicate that the statistics for 2017-18 are still undergoing an audit process, and so the picture might change slightly. And most of these cases we finalize through alternative dispute resolution methods, where there are issues where we call on the affected parties or the warring parties, and then we reach an agreement between them and the state. And we proceed to sign or prepare settlement agreements in this particular instance. Some of these cases are matters that shouldn't be coming to the Public Protector. They can best be dealt with elsewhere, or as well, they can be dealt with by the very same state institutions. That's why this year we will be embarking on a roadshow which will seek to encourage the public to exhaust available remedies before turning to the Public Protector, while at the same time persuading organs of state to establish internal remedies or internal complaints resolution units. This will help free our hands so that we can deal with systemic problems and even go as far as doing more own initiative investigations as provided for in the Public Protector Act. It is only in more complex matters which involve service failure or conduct failure where we issue formal reports. In the 20 months that I have been in the office, we've issued 50 investigation reports, which will include the ones I'll be releasing today. These are not merely numbers. A real impact on the lives of those affected and on state governance systems has been and continue to be made. In the Eastern Cape, we issued the Nelson Mandela funeral report, which I investigated misappropriation of public funds, improper conduct, and maladministration by provincial government. I must indicate that this report is being implemented by the provincial government. Safe to say it's only the Provincial Director General who is taking a particular or a section of the remedial action on judicial review. For residents of notorious Sliplands Hostel in Umlazi, Durban, today is better than yesterday following our investigation and subsequent report with strict directives. There were findings against the police services, which is responding well into our remedial action. I must indicate that officers from the SABC, Public Order Policing and Visible Policing units, and members of the Metro Police are regularly deployed within the hostel to maintain safety, security, peace, law, and order. And other members of the Metro Police are deployed on the outer perimeter of the dwelling. Again, I must further indicate that this provincial police task team is dealing with cases of murder, attempted murder, intimidation, and illegal possession of firearms. The cases have had to be transferred to the task team after the community expressed discontent with Umlazi police station. The cases under investigation by the task team include 57 of murder within the hostel, 14 outside the hostel, and 3 in areas outside Umlazi, and 69 of attempted murder within the hostel and 3 outside the hostel. I must also indicate that social development and municipal services are also being provided at the hostel after our intervention. Similarly, for the community of the informal settlement of Masiphumelele, a stone throw away from the affluent fish hook in Cape Town, Western Cape, an area ravaged by regular violence of service delivery protests before our intervention. Today is definitely better than yesterday, and tomorrow will even be better. The living condition has drastically been improved after we've worked closely with the City of Cape Town and the local community leaders, and we are thankful that some of the community members are also happy with the changed living condition. Further, again, some of the bread and butter issues we've dealt with in Cape Town, one of the complainants who has been waiting for the ID for the past 18 years, we made sure that their matter is resolved, and we know that in South Africa having an identity document is very important because you can access all the services of government. These are things critics will never understand, but even if we wanted to bend backwards for and pander to the critics, we'll still fail dismally, because 9 out of every 10 matters in our caseload are issues that concern people at the grassroots and thus do not generate media appetite as high-profile issues do. Our approach has been to strike a balance between the bread and butter cases and the high-profile matters. We have done well on both sides of balancing act, and for instance, the reports I've issued against or where I was investigating the high-profile politicians who are members of parliament or cabinet, the former cooperative governance and traditional affairs minister and the former public enterprises minister, Des van Rooyen and Lynn Brown respectively, and the president implemented those remedial action. Let me just state this for the record. We are not against criticism. We enjoy no insulation from scrutiny. Ultimately, it is constructive censure, among other things, that builds individuals and institutions. Accordingly, we will continue to welcome criticism with humility, but we will also ignore banter, which is only aimed at projecting us as people who do not know what we are doing when the facts are there for everyone to see. I now turn to the reports that have brought us, or all of you here this afternoon. There are 8 of them. In fact, it's 7. The other one will issue tomorrow morning. They cover the important thematic areas, including violations of the Executive Ethics Code, safety in the workplace, workers' compensation, labor matters, staff appointment, and tender irregularities. The first one relates to Komungwe Security Services in Gasekhonyane Municipality. I investigated alleged irregular and proper awarding of a security tender to Ikodiseng Business Consulting, which is abbreviated as IBC, by the Gasekhonyane Municipality. The complainant is Mr. Mpoos, a director of Komungwe Security Services. He lodged the complaint in 2012 on behalf of his company, alleging that the municipality did not follow proper procurement processes in that it awarded a tender to IBC for a period of 36 months, despite the fact that IBC's bid was non-responsive, in that IBC submitted copies of a tax clearance certificate instead of original documents, and PRISA and triple BEE status level certificates which were not certified. The issues investigated and the findings thereof, whether the municipality unduly failed to follow proper procurement processes when appointing IBC, and whether such conduct constitute maladministration. This issue, the finding was that it was substantiated. The second issue, whether the complainant suffered prejudice as a result of municipalities' failure to follow proper procurement processes, and as well this allegation was substantiated. The appropriate remedial action which was taken in this matter was that the municipal manager should, within 30 days after receiving the report, ensure that all municipal officials are trained in supply chain management and are trained in MFMA, and issue a written warning, a written apology to the complainant within 30 days, and take appropriate disciplinary action against the members of the bid adjudication committee, and compensate the complainant an amount of 2,530 being cost incurred in preparing the bid tender documents. To the municipal council, the council must, within 30 days of receipt of the report, take necessary disciplinary action against Mr. Ndefang, the municipal manager at Kgasekgonyane municipality. There's another complaint we've received, Anonymous versus David Graper municipality. This matter also investigated a certain in fact, the complaint was relating to allegations that a certain Mr. Philander was appointed by the Mir municipality. The Mir has now amalgamated with the Kara Heights municipality to form this David Graper municipality to a post of revenue clerk, even though he did not meet the requirements of the position, and that the appointment of Ms. Junez Foslow was made to the same office without the post being advertised or interviews being held by this municipality. The issues investigated was whether the appointment of Philander was improper, and whether such conduct constitute maladministration, and that allegation was substantiated. Another issue and the finding is that Ms. Foslow was appointed without following proper processes. This allegation was not substantiated because this was an intern who was seconded from one of the setters. The remedial action which I've taken in this matter is for the municipal council to initiate and disciplinary processes against the acting municipal manager, as he was responsible and accountable for the appointment of Mr. Philander. The other matter is Masibi versus the City of Tshwane Metropolitan Municipality. I investigated an alleged maladministration that is said to have occurred during 2009 and 2010 by the City of Tshwane regarding the transfer, non-payment of salary, and disciplinary inquiry of one of its employees, Ms. Masibi. The complainant was an ambulance practitioner with who was employed by the City of Tshwane, and he lodged his complaint with the Public Protector in June 2014. The complainant was previously employed by the City of Tshwane until her resignation in 2015. She alleged that during 2009 and 2010, she suffered improper prejudice as a result of unfair labor practice. The issues which were investigated and the findings, whether the City of Tshwane improperly transferred the complainant from Roslyn Fire Station to Wonderboom Fire Station, the allegation was substantiated, and whether the City of Tshwane improperly withheld the complainant's salary between February 2010 and November 2010, the allegation was also substantiated, and further that the complainant suffered prejudice. The remedial actions which were taken is that the City of Tshwane must, within 14 days of this report, tender a written apology to the complainant, and further they must submit to the Public Protector that written apology, and further that the City of Tshwane should be able, must pay the complainant the amount of the salary which was not paid between February 2010 to November 2010. There would be a 15.5% per annum interest on that, which they also have to pay. The next matter relates to Mr. Silepe and others versus the South African Energy Corporation. This matter, I've investigated the allegation of maladministration level against the South African Energy Corporation by a certain Mr. Manyanyata Silepe and others. A lot of the complainants were former employees of Nexa in Pelindaba, while the rest were subcontractors who previously did business with the corporation. Mr. Silepe and others, they complained that they suffered adverse medical conditions as a result of working for Nexa. They alleged that while employed there, they were not informed about the possible risk of radiation contamination. They also alleged that they were not provided with training on safety and protective clothing, and they further alleged that in some cases they were not legally authorized to work in radiation areas, yet they were instructed to deal with the so-called radiation and hazardous chemicals or clean in those particular areas. So the issues which were investigated and the findings, whether the complainants suffered adverse medical conditions as a result of their employment with Nexa, and did this cause them to suffer improper prejudice. The allegation was not substantiated. Whether due processes were followed by Nexa in the way the compensation fund claims were dealt with, and does this constitute maladministration? This allegation was substantiated. Whether due processes were followed by the compensation fund in dealing with the claims lodged, and does this constitute maladministration? This allegation was also not substantiated. The other substantiated allegation was whether there was failure by Nexa to conduct a proper investigation into the death of Mr. Mota. So this allegation was substantiated. The remedial actions which we've taken, and after having engaged Nexa and Nexa committing to implement, is that the National Nuclear Regulator and Nexa must, within 60 days of this report, subject the employees identified in the report of Mzansi Energy Solution and Innovations, which was appointed by NNR to conduct specialist medical examinations and tests on its behalf between September and November 2016 at various private hospitals in Gauteng for further evaluation as recommended. Nexa must provide all employees with a copy of their exit medical certificates, and the certificates should also be placed in their files. Nexa must, in terms of the personnel protective equipment issued and training on the use thereof, there should be strict compliance by managers. This should be audited annually. All subcontractors must be subjected to ongoing training on all risk factors within the scope of their employment. So Nexa should issue a written apology to Mr. Mota's family for failure to conduct a proper investigation into his death. Nexa must, within 3 months from date of this report, consider paying the Mota family an ex gratia payment amount determined as reasonable consolatory payment for the frustration and distress they have suffered as a result of failure by Nexa to conduct a proper investigation into the death of Mr. Mota. The next report relates to Anonymous versus Mieseta. In this, I investigated an allegation of maladministration and improper conduct in connection with alleged victimization and subjection to occupational detriment of employees on account of them having made protected disclosures in connection with irregular appointment of service providers and personnel, irregular disposal of manufacturing, engineering related services sector, education and training authorities, movable assets, irregular, fruitless and wasteful expenditure, as well as failure by the Chief Executive Officer of Mieseta, Dr. Raymond Andrew Patel, to institute disciplinary proceedings against an employee who is alleged to have contravened the Mieseta Code of Conduct policy. The first complainant is a 46-year-old who is married with 3 dependent children. One of the children has already completed tertiary education, And the matters which we have investigated, in fact, this is an anonymous complaint, therefore that's why they had to describe the complainant we have the way we've described. The issues investigated and the findings, I'll only mention where we have substantiated findings. The allegations which whether the CEO caused Mieseta to incur irregular, fruitless, and wasteful expenditure by commissioning a disciplinary inquiry against the second complainant, which did not yield result and was later aborted, and if so, whether his conduct constitute maladministration. This allegation was substantiated. The other allegation which we didn't make a finding on because the Hawks is investigating whether the CEO improperly influenced and authorized the appointment of certain service providers to render services at Mieseta contrary to legislation and prescripts. Whether the CEO failed to institute disciplinary action against an employee, who we will indicate as Mr. X, who had contravened the Mieseta Code of Conduct, and if so, whether his conduct constitute maladministration. This allegation was also substantiated. So the finding, the remedial action which we concluded on are the Minister of Higher Education and Training must take cognizance of the findings regarding the maladministration and improper conduct by the CEO, Dr. Andrew Patel, mentioned in the report, ensure that the board considers the acts of maladministration, financial misconduct, and proper conduct referred to in the report and take appropriate disciplinary action. The other one to the Mieseta Board of Directors, which must take cognizance of the findings by the CEO and ensure that such action is not repeated, and take disciplinary processes against the CEO, Mr. Raymond Andrew Patel, within 60 days of publication of this report. The CEO should take cognizance of the findings of improper conduct, and that should not be repeated, and ensure that the Mieseta recruitment policy is amended to prescribe for the policy to be followed when a suitably competent candidate for the position is advertised internally and could not be found. The other report relates to Masuka, the Deputy Speaker of Limpopo Provincial Legislature, where it was alleged that he incurred exorbitant mobile telephone bill on an official trip to the United States of America in 2014. This is an own initiative investigation conducted after my office came across an article in the City Press, 29 March 2015, on allegations against the Deputy Speaker. The article alleged that the Deputy Speaker incurred a bill of $125,000 while on an official trip in the U.S., and it alleged further that the manager of the legislature's supply chain management unit, Ms. Tuna, was suspended because she questioned the bill. The following issues were identified and investigated: whether the Speaker incurred an exorbitant or unreasonable mobile telephone bill whilst on an official trip in the U.S. This allegation is substantiated. Whether the amount spent by the Speaker on his mobile telephone bill was exorbitant and unreasonable. This allegation is substantiated. And whether the manager of the legislature's supply chain management, Ms. Tuna, was suspended as a result of querying this. This allegation was not substantiated because we could not get cooperation from Ms. Tuna. I took the following remedial action. The Speaker of the legislature must, within 60 days from date of this report, ensure that the legislature review sections 6.5 and 6.6 of the policy, specifically to provide for the total allowance on combined mobile, telephone, voice, and the mobile tablet and laptop data for members of the legislature per official international trip. And the acting secretary of the legislature must, in consultation with the Speaker of the legislature, take appropriate action and recover a reasonable portion of the amount spent from the Deputy Speaker, which he incurred when he was in the US within 60 days from date of this report. The next report relates to the complaint lodged by Makatla versus Zille, the Premier of Western Cape Province. This allegation was lodged in terms of the Executive Ethics Code was lodged by Mr. Makatla. The complaint was lodged with my office 7 July 2017, and it relates to the violation of Section 1C and D and 3C of the code by conducting herself as follows. She tweeted, amongst others, that for those claiming legacy of colonialism was only negative, think of our independent judiciary, transport infrastructure, piped water, etc. The tweet has brought back a lot of pain and suffering to the victims of apartheid and colonialism in South Africa. She celebrated the oppression, exploitation, racism, and poverty, which are the direct results of the legacy of colonialism. She failed to act in good faith and in the best interest of good governance by making such statements. The Premier's actions did not comply with what was expected from a person holding the office of the Premier of the province. She also failed to act in a manner that is consistent with the integrity of her office. She violated the principles of the Constitution and divided the society on racial grounds. And by undermining South Africans with her personal beliefs on colonialism, she failed to uphold her oath of office, which requires the Premier to hold office with honor and dignity. The following were issues considered for investigation: whether the Premier of the Western Cape Provincial Government, Honorable Helen Zille, allegedly made the twist on colonialism in the media, which allegation is substantiated, and whether the alleged tweets on colonialism made by the Premier violated the provisions of the Executive Ethics Code. The allegation is substantiated. In the light of the above findings, I'm directing the following remedial action. The Speaker of the Western Cape Provincial Legislature must, within 30 days from the date of this report, table it before the Western Cape Provincial Legislature for it to take appropriate action to hold the Premier accountable as contemplated in Section 1142, 133, subsection 2, and 3A and 1361 and 2B of the Constitution. Thank you.
Thank you, Public Protector. We will now open the floor for questions. And I will ask colleagues here to first introduce themselves and indicate which media houses they represent, and then they can pose their questions. And then we will take questions in batches of 4 at a time and allow the Public Protector, assisted by the panel, to respond to each of the questions and then take another round. So let's see by a show of hand who wants to go first. I've noted the colleague over here. Who else wants to pose a question? Okay, up to so far we have one. It's the lady here who will introduce herself.
Good day, ma'am. Sita Kema from World View. I just wanted to find out, you just gave us the numbers of the investigative reports that you've dealt with since your arrival or since you took office. How many of those have been challenged, and how did you resolve the issue then? And then the second question is, I read on an online publication regarding public hearings to be taking place here at the Public Protector's Office, which are the first hearings to be done so by the office. Why this particular case?
I haven't seen any other person wishing to ask a question. In that case, we'll hand over to the Public Protector to respond to those 2 questions. Thank you.
Thank you, Program Director. I hope I'm audible enough. The reports which we've issued, around 50 reports since I've joined the office. Out of those which were taken on review are not more than 10. In fact, even less than 10, which were taken on judicial review. And remember, I indicated that I will try by all means to engage the various state organs we are investigating to make sure that by issuing them the Section 7(9) notice, where we are indicating that they are implicated and they respond to that, we're giving them an opportunity to inform us about their side of the story. So most of the reports which have been issued are not taken on review because we've agreed on with the relevant implicated parties. The public hearings which we will be holding, we're still finalizing the project plan, relate to the Masiphumelele racecourse complaint which we've received. I wouldn't say it's the first one. I think there was another one which was done relating to the taxi, not recapitalization, but then relating to the conversion of the panel vans into the taxis, which was done. This will be another one where it's part of the investigation to determine whether there's any maladministration or any irregular processing of that particular process when the Masiphumelele was, the race courses were transferred to Masiphumelele. So we will indicate and we will inform about the dates of this public hearing. Thank you.
Okay, are there any more questions from the floor? Okay, I've noted 2 this side. Okay, 3. So we'll start with 1, 2, and 3. In that order, please.
Good afternoon, Public Protector and the panel. It's Alvin Sampier from ENCA. Just on the report relating to the tweet from the Premier, Helen Zille, what was her response when you eventually made the finding and told her that this is what you have found and you feel that she must be held accountable by the legislature? And Advocate, there was the report last week that you were expected to appear in Parliament, which you didn't, and you were on Afro Worldview where you indicated why you couldn't make it to Parliament. And in that interview, you indicated that there is interference coming from parliamentarians. Can you just, in terms of the work that you're doing, can you just expand a bit on that? And you also said that you were not even aware that they were going to discuss the issue relating to the Commission of Inquiry or the inquiry into your fitness to hold office.
From Jacaranda FM. Is there an update on the investigation into the fitness to hold office of the former Finance Minister, Malusi Lugaba, the current Minister of Home Affairs?
Alex Williams from Reuters News Agency. You said that roughly 9 out of 10 of the cases that you investigate relate to grassroots issues. But for the 1 out of those 10 that are the big ticket items, the one that everyone concentrates on, and things like corporate malfeasance by large international companies, how many investigators is the Public Protector able to dedicate to those sorts of cases? And at the moment, do you have a lot of cases which are currently being investigated involving large foreign firms involved in corruption during Mr. Zuma's time in power? Thank you.
Thank you. We'll now hand over to the Public Protector to respond.
Thank you for the questions. Aldrin, I must indicate that the meeting with the Portfolio Committee, I'll repeat again, yes, the invitation I received was an invitation to discuss the rules, public protector rules, and the issue of the policy on appointing the special advisor. So the issue of my fitness to hold office was not part of the items on that particular agenda, and I think I've indicated that that process can take place even if I'm not part of that particular meeting. So, and I indicated why I didn't delegate that particular matter, because it was relating to the rules and the policy, of which those two were not delegated to any other person. So the issue of interference is more on appearing before the Portfolio Committee, and most of the time ending up dealing with the matters which are before court and matters which are bordering around issues of further also interfering with the work of the Public Protector, because I said I expect the Portfolio Committee and institutions of the state to support the Chapter 9 institutions. Hence, the Chapter 9 institutions, we are there to strengthen this constitutional democracy. Therefore, we wouldn't be able to do that if we do not receive the necessary support. And again, the necessary support for us to do the work, to be able to protect the very same grassroots we are referring to. The Malusi Gigaba matter, the investigation is it's progressing well. We've received the response from the minister. The investigators are now analyzing the responses to determine whether there is any irregular or any conduct which we can make a finding on. Reuters, the issue of grassroots, yes, 90% of our investigations relates to bread and butter issues. But then when it comes to issues relating to corruption, especially corruption which is done by state institutions, because we don't have jurisdiction over private companies, definitely we have a branch within the Public Protector which deals with those good governance and integrity cases, and a lot of them relates to corruption. I must also hasten to say that they are very complex matters which should be taken to court actually, but we are investigating them, and you'd find that an investigator has up to 15 to 20 of those very complicated matters. Hence, we take up to 24 months to finalize those investigations. I must say that we've referred some of the matters relating to the state of capture to the Commission of Inquiry, especially because it falls within their mandate, and again, the Commission is well resourced to deal with those matters.
There's just one that was not responded to, PP, relating to the response of the Premier of the Western Cape.
I thought I will give it to Mr. Ndo to take you through. The response of the Premier was received the 15th of March 2018, where the Premier indicated that my conclusion that her tweet gave rise to the constitutional and statutory infringement will amount to and represent an arbitrary and irrational decision which will not withstand judicial review scrutiny. So the Premier felt that it was within her rights to tweet like that, because in terms of the Constitution, she has freedom of expression. So that was her view, that there's nothing wrong which she has done.
Thank you, Public Protector. Do we still have any more questions, ladies and gentlemen, before we...
Can I just quickly follow up then?
Okay, Aldrin, and then the gentleman right behind you.
So, Public Protector, does this then mean that Helen Zille, the Premier, may have already indicated that she will be taking this report for judicial review? And the other question is on the interference by Parliament. Would you make the argument that Parliament is making it difficult for you and this office to do its job in terms of the Constitution? And the final question is with regards to the state capture inquiry. Have the commissioners been in contact with you? And have they asked you to appear before the Commission of Inquiry? And is there any evidence that you may have handed over to this Commission of Inquiry so far?
Good afternoon. It's Alex from News 24. Just in terms of former Minister Lynn Brown, you said you were happy with the action taken by the President. I'm assuming you mean the removal. I just want to know if he ever wrote to you that the action was taken and whether he provided this report to the National Assembly on the action taken. Thank you.
Thank you. Over to you, PP.
The follow-up by Aldrin. The response by Madam Zille, it's yes, was stating that she doesn't agree with the finding because when we issue the Section 7.9, we issue the Section 7.9 indicating that you are implicated, and these are the findings which we will be having. Yes, she indicated that, but then at the end of the day, taking the matter on judicial review, any person has a right to do that. And again, that matter will be ventilated by another forum. There's nothing wrong in her doing that. And I think it's not a reflection on us or on her. So I think we've tried our best by bringing the matter to her attention, but she has a right to do that. The issue of Parliament, Aldrin, it's more of requesting Parliament's support because in terms of the Constitution, Section 181, 3 and 4, it does provide that organs of state and anyone should support the Chapter 9 institution, and no one should interfere with the functioning of the Chapter 9 institution. So sometimes when other issues are dealt with, it's as if there's a lot of interference. And I must indicate that those are issues I'm trying by all means to bring to the attention of the Speaker and even the Chairperson of the Portfolio Committee that we need to resolve them. I don't think it's fine for us to be dealing with such issues in a manner which we are dealing with. On the Commission of Inquiry, we issued a statement where we handed over all the state of capture investigation report and the evidence which we handed over to the Commission. I think we said it was around 110 or 127 Act-Lever files. And there's also complaints we've received from CASAC, which were related to the state of capture. The issue of ESCOM, Makoko, and Minister Brown's handling of the ESCOM matter, and the Malusi Gigaba issues when he was still the Minister of Public Enterprise. So all those have been handed over to the Commission of Inquiry. I must indicate that, no, they have not yet indicated anything about whether I should appear or to come and give evidence, because we have handed over the information. I think the last time they said they are analyzing the information. If they need any clarity, we are willing. But again, remember, they are complainants. Therefore, they might not need to come back to the Public Protector. They can directly contact the complainants in this matter who can provide more information. On the issue of Brown, I indicated that I was reflecting on the impact of our reports and indicating that the President wrote a letter, yes, indicating that he has implemented or he has acted on the Public Protector report and implemented the remedial action, and he indicated that he will be tabling that before the National Assembly. So for us, on our side, we have taken it as being a remedial action which has been implemented. Maybe just to clarify the issue of the race horses, it's relating to Phumelela, not Masphumelele. Apparently I said Masphumelele, but it's Phumelela race horses matter.
Okay, thank you. I don't see any more hands from the floor. In that case, I will then proceed to thank you for honoring the invite and for participating, and thank the Public Protector for assisting us with clarity on all of these issues as well. All of the reports that have been released here will be uploaded on the website soon, but I'm sure you have in front of you fact sheets on the basis of which you can do your work for now. Thank you so much.